next matter to come before the court this morning is in Re Estate of Sylvia Von Meyer. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve any of that time for rebuttal, if you let me know, I'm keeping the clock. I can keep the price of the passage of time. We have read the briefs and we are ready to proceed when you are.
Good morning, Ron. My name is Jonathan Lindemann. It's my privilege to appear before you on behalf of Ferdinand Von Meyer. I would like to reserve some rebuttal time, but I anticipate that I'm going to use some of my preliminary presentation that won't matter. I'm sure you're well aware, my client has been suffering from dementia for quite some period of time. He had married twice. His second wife was Sylvia Von Meyer. I guess maybe rather crass to say, but obviously my client defeated the Sylvia Von Meyer's plan and her sisters to survive him. She unfortunately died. She tried to add her two sisters, Kathleen Payne and Judy Clare, to some of these accounts. Unfortunately, the sisters could not wait, I guess, until their Sylvia expired, and they went and looted the accounts. Not only did they loot these accounts, but I believe it's 9 days after Sylvia passed away, they managed to contact Wells Fargo and change what had been a joint tenant account for all of the statements that I could find, dating back to April of 2006, and before was a joint account. 9 days after Sylvia passes away, that account all of a sudden becomes a joint account of right survivorship, and all the money is transferred to the executor in this case. And the insult to injury, the executrix, Ms. Dane, opened an estate and claimed there were absolutely no assets. It was opened purely for litigation purposes. The litigation was a lawsuit that I filed in the General Division of the Common Pleas Court, seeking the money from these accounts that they wrongfully took. The case was tried on the last day of the trial when we were preparing the jury charge. Both Kathleen Dane and her sister Judy Clare decided that they should offer to pay the money back if I would forego the statutory penalties, which I agreed to do. $24,000 of that money went to my client, and $54,000 was made payable to the estate of Sylvia Von Meyer. The estate has additional heirs besides the two sisters. There's a nephew that was provided for, and the Clearview School District was provided for. Despite the fact that there's $54,000 sitting in the probate clerk's account waiting for distribution, no inventory has ever been filed reflecting the assets that my clients claim exist, which my clients have admitted existed. It just hasn't been done. The only inventory that's been filed is a $2,500 retirement check from PERS and a note that alleged that my client owes the estate. Despite the fact that the executrix filed an estate saying there were no assets, she then filed a concealment of assets claims against my client and his brother, saying that they took assets from an estate that has no assets. My client and his brother answered saying, yes, there are assets, they're still in the house, and by the way, the other two sisters took some of the stuff from the house, which should be returned or at least included in the inventory. We had a hearing before the magistrate. All of these facts are admitted. There's nothing in dispute. But despite the fact that there's an action pending trying to seek to recover $80,000 from Wells Fargo and the executrix, despite the fact that she admitted taking this money, despite the fact that she never filed an inventory reflecting these assets, the magistrate somehow found that there was no finding of fraud against her. I have to respectfully submit to the court that this executor is not one that should be removed as a result of this. understand the statute says that the trial court, probate court, has exclusive jurisdiction and may remove the executor upon the findings of these things that have occurred. I think that even though it's not a mandatory duty, that the statute requires in some common sense duty to remove an executrix that has a conflict of interest with the estate, still paying to the state, has admitted to stealing money, has not filed the proper paperwork, and has made no effort whatsoever to live up to her duties to garner the assets of this estate, much less steal from them, that she should have been removed.
On the hearing regarding her removal, was the failure to file an inventory or any other document relative to her fiduciary duty in the court with respect to the estate, was that raised?
Yes, and it was raised, and not only that, the magistrate asked what efforts she has made to collect on a $76,000 note, which she claims exists and is uncollected. There was an inventory filed. The inventory, as I said before, reflected two assets, a $2,500 PERS check and this note that allegedly my client owes the estate.
Was there any filing relative to that inventory? Any specific filing that the inventory was not complete or?
Yes.
Okay.
And not only was there a filing based on that, I filed a concealment assets case to include those assets and to include the $54,000, which is sitting in the probate court. No one's even recognized in any official document that that money's there. My client obviously elected to take against the will. His second wife tried to cut him out of the estate, so he has an interest in the estate. And as far as I know to this day, the two other heirs, the Clearview School District and the nephew, have no idea their assets in this estate because there's been no filing, no notification. The only thing they got was a preliminary filing saying no assets exist, and the estate was open for the purpose of litigation only. The illogic, the incongruity of this just frankly is beyond my understanding. Thank you.
Thank you, Councilman.
May it please the court, my name is David Collis. I'm the attorney for Kathleen Dane, the executor of the estate, and the estate of Sylvia Von Meyer. I would like to address a few of the things that counsel has said. The estate was originally open for litigation purposes only. The executrix was not aware of any assets until she subsequently found out about the OVERS benefit, which was $2,500. And also she found what appeared to be a promissory note that Ferdinand Von Meyer had signed in favor of Sylvia Von Meyer. I would say it would be of doubtful enforceability, but it is there, and it was disclosed. She has not yet made any serious effort to collect that money from Mr. Von Meyer. As a surviving spouse, he is entitled to a share of the estate, and I believe that it's her intent, if the promissory note is determined to be valid, that it can be charged against his share of the estate. There doesn't seem to be much reason to actually file a lawsuit against Mr. Von Meyer at this point. In terms of the Wells Fargo account, that's the only claim currently open. There were two accounts that Ms. Dane was a joint owner of. She believed they were survivorship accounts, and I think without much consultation, she did close those accounts prior to the death of Sylvia Von Meyer. That's been litigated, it's been settled, and the funds have been paid. At no point did Ms. Dane try to conceal what she had done. It was pretty much all open and above board. In fact, in the magistrate's decision, Magistrate Harkis specifically addressed that and said that she had not engaged in fraudulent conduct.
Didn't he say that he could not find that she engaged in fraudulent conduct because it was a settlement agreement?
I don't think he said because it was a settlement agreement. I think the phrasing in the magistrate's decision was that he could not find it was fraudulent conduct.
Okay.
The magistrate also made a specific finding that she did not steal assets. So I think some of the assertions of counsel in this for Mr. Von Meyer are somewhat hyperbolic and really not supported by the hearing, the testimony of the hearing. Our position is that the the testator has the choice of who is to be the executor, and that decision is not generally rejected by the probate court unless there's some good reason, like fraudulent conduct or criminal conduct or incompetency and things like that. The decision to remove an executor is wholly discretionary with the probate court. And in this case, these arguments were raised before the magistrate. The magistrate took it under advisement and made a determination based on all the testimony of the hearing that the executor should not be removed. When the appellant filed objections to the magistrate's decision, the probate judge did an independent review and examined the transcript and also determined that the executrix should not be removed. And if you look at the statutes, 2109.24 and 2113.18a, which authorize the removal of an executor, they remain discretionary with the trial court. And this trial court has reviewed the evidence and determined that there's not sufficient basis to remove the executor. With respect to the open claim, which involves the Wells Fargo account, that case is currently before the probate court, the same court that is supervising the executrix. So at this point, and really at all points until now, there's not been any real opportunity for the executrix to take advantage of Mr. Von Meyer. And it's difficult for me to see how it could happen before this estate is closed. That really concludes my argument. If there are any questions.
Thank you, counsel.
The magistrate found in the last line of his opinion, which is on page 6 of the appendix, there has been no finding of fiduciary malfeasance. Absent such a determination, I recommend the motion remove the executrix be denied. It's his province and solely his province to make that finding. Refusing to do his job and then citing it as the reason for not doing it, I think is got to be one of the greatest examples of circuitous logic I've ever encountered. And I also don't understand how an executrix can say she's not aware of assets that belong in the state when she admitted swiping. I mean, I think when you go down 3 days early and clean out somebody's accounts, it's pretty hard to come to court and say with a straight face today that she didn't know there were assets. She took them, she did conceal them, she put them in her own name, she transferred them to other accounts. That's exactly what she did to Wells Fargo. 9 days after her sister's death, the executive took that $80,000 and made it a survivorship account. How that can happen, I don't know. The other thing that it was been argued all along is the minute a member of a joint account becomes incompetent, that account's dissolved. And the only thing you can get out of it is what you put in. And both of these sisters, the executrix and Judy Claire, have admitted they contributed nothing to any of these accounts. Yet they couldn't even wait till her sister died. They weren't going to share them with the accounts of the other members who were also allegedly joint survivors and joint tenants, but they took the money. There was a 4-day jury trial, and they had to pay it back at the end of that trial. To say that is not malfeasance as the executrix of an estate, I don't know what else is. And the other thing is, I think everybody knows that before you can collect on a survivorship account, as a survivor, you need someone to die. And that didn't happen here. She couldn't wait for that. Even though the account was dissolved as a matter of law, the moment my client became incompetent. So in any event, I respectfully say to you, and I don't mean any disrespect to the probate court, but I don't understand how something like this can go on, or why my client still has to battle an executrix of an estate that has a duty to go out and get this $80,000. If they're an independent person as the executor of this estate, they would be suing this person, not my client on his dime. And that's what is supposed to happen. So I respectfully ask on behalf of Bernard Von Meyer to find that the trial court abused its discretion by not removing Kathleen Day.
Thank you both for your presentations this morning. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal as well as posted on the Ohio Supreme Court website. Thank you. We're adjourned until next Tuesday.